Hello, and welcome to the second seminar on the Reality of Net Zero series. The purpose of the series is to explore why we need net zero, what progress we have made towards it and not made towards it, and how we can achieve it in a way that is fair to everyone. The series is hosted by Oxford Net Zero, the Zero Institute, and OxEarth, and lasts for 8 weeks. If you would like to find out more about the upcoming seminars in the series, please visit the link posted in the chat where you can read more and sign up for individual talks. Please post any questions to the Q&A section of the webinar and not within the chat, as we won't have access to the chat during the talk. The topic of today's talk is Getting Net Zero Right, the Role of International Law, and it's going to be presented by me and my colleague, Ewan White. It won't surprise you that our conclusion to the question of whether international law has a role to play in getting net zero right is that it does. In fact, it has a critical role to play in getting net zero right. What we propose to do in the next half an hour or so is to talk you through some of the context for the temperature and net zero goals in the 2015 Paris Agreement, take you through some of the evolving science since the Paris Agreement was signed in 2015, how the states and the UN climate change regime has actually responded to the science, what changes there have been to projections of temperature increases as a result of the evolving science and the responses of states, and yet the credibility and accountability concerns that remain. Our central question here that we seek to address is whether international law actually addresses any of these concerns, and as I said, we believe it does. We demonstrate this through an illustrative deep dive into the issue of CDR, carbon dioxide removal, and the role that carbon dioxide removal plays in achieving net zero. We do this in part by finding a duty of due diligence in relation to states' actions on climate harms. We look at the sources for this duty of due diligence. We look at the standard of due diligence that attaches to this duty. And in particular, we argue that this standard of due diligence is an objective standard, which is related to concrete benchmarks, which we will run through in the course of this talk. We then take a deep dive, as I said, into the scientific context for CDR, and my colleague Ewan will address how this standard of due diligence, the stringent standard of due diligence we hope to establish in the first half of our talk, is actually applied in the context of CDR. So the Paris Agreement and the context for net zero and the temperature goals. So Article 2.1 of the Paris Agreement contains the temperature goal. It contains other goals as well, but this is the quantified temperature goal of the Paris Agreement, which is located in Article 2.1, which is also characterized as the purpose of the Paris Agreement, is to hold temperature increase to well below 2 degrees above pre-industrial levels and pursue efforts to limit the temperature increase to 1.5 degrees centigrade above pre-industrial levels. The net zero goal that follows on from this temperature goal is contained in Article 4.1 of the Paris Agreement. It's worth noting that the Paris Agreement doesn't use the term net zero either in Article 4.1 or anywhere else. This is a term that has evolved in the scientific literature and in subsequent Conference of Parties decisions, but not in the Paris Agreement itself. The Paris Agreement characterizes what we've now termed net zero as a balance between anthropogenic emissions by sources and removals by sinks of greenhouse gases in the second half of the century. And parties are to aim to reach global peaking of greenhouse gases as soon as possible and to undertake rapid reductions in science so as to achieve this balance. Since the Paris Agreement was signed and adopted and entered into force in 2015-2016, the science has evolved and advanced quite significantly. Most noticeably in the IPCC's 1.5 degree report in 2018, which was a report that was produced as a result of a request by the Conference of Parties in 2015. This report found that there were robust differences in impacts between 1.5 degrees centigrade and 2 degrees centigrade, and that there were two pathways to 1.5 degrees centigrade globally. one of those pathways to stabilize at or below 1.5 degrees centigrade, which at this point looks unlikely. And the other pathway is to overshoot and then return to 1.5 degrees by 2100. The extent to which this maps on to the Paris Agreement itself is something that we will address in later slides. To limit warming to 1.5 degrees with no or limited overshoot, the IPCC's 1.5 degree report found that net global CO2 emissions would need to fall by about 45% from 2010 levels by 2030 and reach net zero by around 2050. So the science advanced quite considerably, even in the 3 years since the Paris Agreement was signed. How did the UN climate change regime respond to this? And the response of the UN climate change regime was quite heartening. In the 2021 Glasgow Climate Pact, for the first time, but subsequently in the Sharm el-Sheikh implementation plan and the UAE consensus, there is a clear shift in emphasis from well below 2 degrees centigrade, which we find in Article 2.1 of the Paris Agreement, to 1.5 degrees centigrade. The repeated emphasis today is on 1.5 degrees centigrade, not well below 2 degrees centigrade, which is, of course, something some state parties are beginning to question, given 1.5 degrees is seeming increasingly out of reach. There's also a shift in the regime from aiming to reach net zero greenhouse gases in the second half of the century to an emphasis on net zero CO2 by or around mid-century. Interestingly, these net zero targets, which many states have adopted, and I'll come to it in a minute, these net zero targets have been integrated into the Paris architecture through the long-term low greenhouse gas emission development strategies that states are encouraged to provide. So states are encouraged to provide these long-term low emission development strategies in Article 419 of the Paris Agreement. And in Glasgow and subsequently, states were asked to integrate into these low emission development strategies net zero targets that they had. To date, about 75 long-term low-emission development strategies have been put in place. States have also responded quite hearteningly to the advances in science. At the time of the global stocktake, the first global stocktake was conducted at the UN Framework Convention on Climate Change and Paris Agreement. Net zero emissions targets covered global emissions of about 89%. Nearly 90% of global emissions were actually covered by net zero targets from states, including all major emitters. And these net zero targets were either agreed in law, were part of an initiative, or were under discussion, but about 90% of global emissions were actually covered by net zero targets. All of this, of course, is quite heartening, and this has led to many sort of promising projections of decreases in the expected increase of global temperatures. So if all nationally determined contributions that are short-term contributions and net zero targets, long-term strategies are implemented in the most optimistic scenario, we would limit temperature increase to 1.9 degrees centigrade, but this is, of course, sort of premised on all sort of pledges and targets being implemented. If only 2030 targets are implemented, the temperature increase predicted to about 2.6 degrees centigrade. So a lot rides on the long-term pledges that states have made in relation to net zero and to achieving those in order to get down to the more manageable 1.9 degrees centigrade. The global stocktake, the first global stocktake under the UN climate change regime, found that notwithstanding the fact that the Paris Agreement had brought down the sort of expected temperature increase from about 4 degrees centigrade in the lead up to Paris to about 2.1 to 2.67 degrees centigrade, it nevertheless found that global emissions were not on track to achieving net zero or the temperature goals, well below 2 degrees or certainly 1.5 degrees centigrade. This then raises questions about the extent to which many of these net zero targets in particular are credible and accountable. So can international law actually address concerns over credibility and accountability of these net zero targets? Now, issues of credibility and accountability span a whole spectrum. In relation to credibility, for instance, there are questions about what form these net zero targets take, both internationally and domestically. Are these net zero targets sort of embedded in law domestically, or are they merely a promise or a policy? What form do they take in international law? Are they embedded in the long-term low-emission development strategies of states? As I said, there are about 75 of these in place. And only some of them have the net zero targets embedded within them. So are they embedded in them, or are they just pledges that are made at COPs? Are they even covering all greenhouse gas emissions or just CO2 emissions? There are open questions around quite a few of these issues. There are also questions around the extent to which nationally determined contributions are aligned with mid-century targets, or is there a huge reliance on carbon dioxide removal so are there short-term targets actually premised on excessive reliance on carbon dioxide removal in the long term? We will, as I said at the outset, do a deep dive on the issue of CDR in a minute to give you an illustrative insight into how international law can actually play a role here. But for now, I'm just noting that these are one among many sort of credibility issues that that arise in the context of net zero. There are also several accountability issues that arise in this context. For instance, to what extent are these net zero targets actually integrated into the UN climate change regime, and to what extent is there any accountability for delivering on these net zero targets? What kind of transparency is required in relation to these net zero targets? What kind of follow-up is required? And what kind of challenges there are with respect to intergenerational justice and intergenerational equity, in that to the extent that states are sort of limiting rapid and steep reductions in the near term and postponing action to later on the promise of CDR removal or other other technologies, does that not pose a significant burden on future generations at the cost of current generations? So these are all questions of accountability that arise, even intergenerational accountability that arise in the context of net zero targets, which are longer term. So there are significant credibility and accountability issues, and international law can play a role in addressing some of these. So to give you a illustration on how international law can actually play a role in this area, we've decided to take a deep dive into the issue of carbon dioxide removal. As we know, all IPCC 1.5 degree centigrade scenarios require carbon dioxide removal. Those scenarios that actually cut fewer emissions in the short term require carbon dioxide removal at scale, and they also create long-term dependence on carbon dioxide removal. And in this context, it's worth noting that many states' nationally determined contributions and long-term low-emission strategies rely heavily on novel and conventional carbon dioxide removal to meet climate targets. And there is very limited sight or transparency on how they're going to do this and what pathways they're going to adopt to do it. So there's very limited information that we have, and there's a lot of ambiguity in the information that is provided in relation to their use and reliance on CDR. There are distinctive risks and uncertainties that attach to CDR, including the risk of non-delivery, and there are social, environmental, and economic impacts. Yun is going to sort of dig a little deeper into those risks and uncertainties, but it's worth noting at this point that these risks and uncertainties can change the magnitude and duration of overshoot, which will then risk exceeding tipping points, which of course will, as we know, lead to catastrophic impacts beyond what we have already experienced, and could also significantly diminish the likelihood of meeting the 1.5 degree temperature goal. So are there any legal limits on the use of CDR by states? We are a group of sort of interdisciplinary scholars in the process of sort of finalizing 2 papers on this issue. And what we're going to do in the next little while is to give you a little insight into some of our key findings. The first paper, States' Dependence on Carbon Dioxide Removal Jeopardizes Climate Targets, Paris Targets, is sort of does a overview of the science, and the second one looks at the legal limits that attach to that science. So legal limits on states' dependence on carbon dioxide removal to meet Paris targets. We're going to focus primarily on aspects of the second paper today, but these 2 papers sort of are interlinked and complement each other. So the regulatory framework that we have identified that applies to states' sort of use and deployment of CDR is the fact that states have a duty of due diligence in relation to their actions to address climate harms, but also actions that cause climate harms. And we derive and find this duty of due diligence from 2 sources. The customary international law principle of harm prevention, that states have a responsibility to prevent harm in areas beyond their national jurisdiction, transboundary environmental harm in areas beyond national jurisdiction. This is a binding obligation, customary international law obligation in international law, and it entails an obligation of conduct, though not of result. So there are due diligence sort of benchmarks attached, or a standard of due diligence attached to this obligation of conduct in relation to the harm prevention principle. There are also obligations of conduct in the Paris Agreement, notably in Article 4.2, where states have are obliged to take domestic mitigation measures, and there are obligations of conduct attached to those, which then entail a standard of due diligence. I'm happy to sort of elaborate on this in the Q&A, but for current purposes, I'm going to leave these sources of due diligence aside and focus on the objective standard of due diligence that actually attaches to this duty of due diligence. So the reason I say it's an objective standard is because it is not determined based on subjective will of states, what they do, but it is dependent on concrete benchmarks. It is an objective standard, and this is something that the recent ITLOS sort of tribunal's advisory opinion on climate change also highlighted. It's an objective standard, and some of the benchmarks that are associated with this objective standard are best available science, which is in Article 4.1 of the Paris Agreement in the preamble, but in several other provisions as well, and underpins the climate change regime. The Paris Agreement's temperature and net zero goals, which I spoke about earlier, which have been repeatedly sort of reinforced in subsequent Conference of Parties decisions. The highest possible ambition, the normative expectation of highest possible ambition, which we find in Article 4.3 of the Paris Agreement. Again, there's a strong normative expectation that parties' actions will align with all of these, will align with best available science, will align with Paris Agreement's temperature and net zero goals, and the highest possible ambition. All of this is also underpinned by the principle of precaution, or the precautionary approach, as some characterize it, in that the principle of precaution, or the precautionary approach, is in Article 3 of the Framework Convention on Climate Change. It's also attached to the obligations of due diligence in the customary international law context of harm prevention. And precaution dictates that we minimize sort of overshoot, for instance, that we minimize excessive reliance on CDR, which would then lead to overshoot, potentially lead to overshoot. There are also sort of requirements in relation to transparency, both in nationally determined contributions and long-term strategies. All of this suggests that, as I said, that there is a framework, a regulatory framework that applies in relation to CDR as well. And although CDR is not explicitly regulated, it is implicitly regulated by this international regulatory framework. I'm going to sort of pass it on to Ewan to talk about the application of this due diligence framework to CDR.
Thank you. So I'm going to do two things now. The first is to give a bit of the scientific context on the possibilities and risks introduced by CDR. And then, in light of that scientific context, we'll get into more detail on what due diligence means in this context. So, the first thing that I want to flag up about CDR is that in addition to the fact that we need to do some of it, and that pathways with less stringent near-term cuts in emissions mean higher dependence on removals, there are different sorts of dependence on CDR. So two sorts of dependence that I want to flag up here. The first is the use of CDR concurrently with emissions to counterbalance excess emissions. So this is what you can see in this, the figure that's been included here, where we have two different scenarios, both of which reach net zero by balancing ongoing emissions with removals, but they do it at very different levels of ongoing emissions and removals. So you can see in the darker core in the middle here, we have scenario one, where we have relatively modest ongoing emissions and relatively modest removals. And in scenario two, in the lighter colors, we have much more significant ongoing emissions, but balanced out by much more significant removals. And what you see in the orange line along the bottom here is that these two different ways of getting to net zero could be consistent with the same temperature. You could limit the temperature increase to, say, 1.5 through these two quite radically different approaches. The second potential use of CDR is essentially to postpone cuts in emissions. So in this scenario three, which is included in this figure here, we reduce emissions less rapidly in the short term, but then claw them back through much more large-scale carbon dioxide removals in the longer term. And so what a scenario like this does, and so you see in the bottom figure here, is mean an overshoot in temperature, that is we would go over 1.5, and then through the use of emissions, carbon dioxide removals further down the line, return below that level. So we have two different ways in which CDR can be used, and these different ways both raise risks of their own that are worth flagging up. So on that, the point about using CDR to enable overshoot, some of the key risks involved with CDR, this is where they come up. So part of the problem is that if you increase temperature beyond 1.5 degrees and subsequently return below it, during the period of overshoot, we're going to have lots of impacts that we wouldn't otherwise have had. And some of those impacts are going to be irreversible. So even if we come back below 1.5 degrees, we might still see the loss of coral reefs, the loss of ice sheets and mountain glaciers. And there are some distinct risks above 1.5 that we wouldn't see below it, like species extinctions and the shifting range for diseases. And of course, one of the biggest issues is that during the period of overshoot, we're more likely to trigger feedbacks that amplify further warming. And in the context of those feedbacks, it becomes increasingly difficult to ensure that we are able to actually get back down below 1.5 degrees. So there's no guarantee that we will be successful in our aspirations to have a temporary overshoot if this is the path that we go down. But there are also risks involved, even in the model where you, at least ostensibly, keep warming to 1.5 degrees. So the scenario that we have in the light gray here involves heightened risks because it's quite possible that we might plan to have less steep reductions in emissions now, compensated by greater removals further down the line, and yet fail to achieve this because CDR isn't delivered. Either we don't get around to deploying it because of technological feasibility issues, or we deploy it, but in a way that isn't permanent. And that's a particular concern for land-based CDR methods. So removals that we might think we've banked then end up being re-emitted. And one of the consequences of that is that if we plan on having significant amounts of removals and then fail to deliver them, we end up in a scenario with greater overshoot than we had expected. So the two sort of sets of risks dovetail together. And so in light of that, the question is, what does international law tell us about this situation? And I'm going to explore that through two parts. The first is that this due diligence framework that Lavanya laid out tells us that due diligence requires the minimization of overshoot. And the second is a set of guardrails that are suggested by due diligence, even within that context, about how to reduce the risks that we see as potentially arising. So in the context of the minimization of overshoot, one question here is, what does the Paris Agreement say? And the key thing to note, to start with, is that the Paris Agreement doesn't say anything explicitly about overshoot. And that raises at least the theoretical possibility that someone could argue that an emissions pathway at the global level is consistent with the Paris Agreement, with a 1.5 degree target, as long as we eventually return below 1.5 degrees, no matter what the magnitude and duration of overshoot is in the meantime. Is that aligned with international law? We think it's not. And we want to suggest that only pathways that minimize overshoot are compatible with the Paris Agreement. And the key basis for making this claim is to look at the object and purpose of the UNFCCC and the Paris Agreement. So Article 2 of the UNFCCC lays out what the point of all of these agreements are, which is to avoid dangerous anthropogenic interference with the climate system. And what we've established in the insight into the risks of overshoot that we laid out there is that many of the dangerous anthropogenic interferences will take place if we enter a temporary period of overshoot, even if we have the intention of later reducing temperatures back down to a safe level. So it's not consistent with the purpose of the Paris Agreement and the UNFCCC and the due diligence standard to deliberately aim for a pathway that increases your risks of exceeding 1.5 degrees. What you should be doing as a duly diligent state is acting consistently with the need to minimize overshoot to whatever degree possible. And right now, a good proxy for that, we would suggest, is the IPCC's C1 pathways from AR6, which is a bit of a technical detail, but essentially what those do is they stay below 1.5 degrees with no or limited overshoot. And no or limited there is understood as only exceeding 1.5 degrees by up to 0.1 degrees and for no more than several decades. This is the kind of thing that a duly diligent state would be trying to act in line with. And the second key point I want to make about the implications of due diligence for CDR is that it gives us suggested guardrails for how states ought to act in putting together plans for CDR deployment. So I'm going to discuss two of these guardrails. The first is that states should prioritize emissions reductions over removals. And partly we can ground that in the text of the Paris Agreement, which puts a lot of emphasis specifically on emissions reductions, not equally on emissions reductions and removals. But also in the discussion that we've just had, that our dependence on CDR being high heightens overshoot risks that are associated with non-delivery. So if we plan to do lots of CDR and later fail to do that, we end up back in the territory of all of these problems we've been discussing. What this doesn't provide as a guardrail is precise limits on the appropriate role of removals. It's not going to tell us exactly how much residual emissions states should have at the point of net zero or in the lead up to it. And that's going to vary between countries, and it's going to vary over time because it's partly a function of technological feasibility and social questions about the desirability of ongoing activities. But what it does do is pull strongly in favor of deep cuts in gross emissions. And it underlines the importance of asking which of these activities are genuinely socially necessary. When we look at current projections for expected residual emissions at the point of net zero, there are some activities there that are very highly represented because they're very technologically difficult to abate if we assume that we're going to keep on doing them. And that includes things like aviation, and it includes things like animal agriculture. And I think one of the suggestions that comes out of this exercise is that we should be really thinking very deeply about which of these emissions we can really not do without. But of course, this guardrail doesn't give you answers to that. It raises this question that states should be thinking about as they attempt to satisfy their obligations under the climate framework. And the second guardrail I want to mention is the need to pursue feasible and coherent mitigation strategies. And the key here is that it's not enough just to set a target for net zero. You also have to have a plan to enact it that has a reasonable prospect of success. And in this context, that doesn't mean that states have to implement a specific sort of policy or strategy. So linking back to last week's seminar, for those who were there with Miles Allen, he flagged up the possibility of implementing carbon take-back obligations. The due diligence framework isn't going to tell you whether or not that's something that states should do, as opposed to, for example, public procurement of removals. But what it is going to tell you is that in your strategy for getting to net zero, you shouldn't be basing your strategy on dubious assumptions. For example, inflated projections of the land sink, which was also a topic of Miles's talk, or failing to address potential trade-offs between different forms of CDR or between those forms of CDR and other mitigation priorities. And in addition to these sort of substantive guardrails that I've laid out, we can also have a discussion leading out of that about the procedural implications. So Lavanya mentioned the important role of transparency here. If we take seriously these priorities that we should have on prioritizing emissions reductions and ensuring that we have feasible and coherent strategies, then this has implications for the kind of information states should be thinking about and should be providing within their plans. So as a very, very basic first step towards trying to ensure that you prioritize emissions reductions, you should be distinguishing between the emissions that you're producing and the removals that are balancing them. And very often we're finding states don't do that within their long-term strategies. They'll have a net zero target without telling us how many emissions they're expecting to be having at that point. And there's a whole set of other requirements that we can sort of build off the idea of the need for feasible and coherent strategies. So the key point there is that states are not meeting anywhere near those kind of standards that we might hope they would in order to abide by due diligence. So that brings us to our conclusion. And I think the overview here is an answer to our initial question. International law does have a critical role to play in getting net zero right. And we have a stringent standard of due diligence that applies to states that can be derived from the international legal framework. And what that standard tells us in the context of CDR specifically, as we've illustrated, is that states need to have credibility and accountability in their mitigation strategies. They need to minimize the extent of overshoot, given the risks associated with it. And it suggests several more specific guardrails that should start to inform states' thinking on this. And pulling all of this together, the key implication of all of that discussion is that the international legal framework and due diligence pulls very strongly in favor of steep emissions reductions in the short term. That's the way to minimize all of the different risks that we've outlined. Thank you very much. I think we're going to discuss some of your questions now.
Thank you, Ewan. So to start off with sort of a really interesting question, I'm sure a question that's in the top of many many in the climate world. What is the impact of Donald Trump's presidency on net zero, but more broadly on, I guess, our commitment to the climate agenda? So if I could take this, Ewan, I might just begin by saying that this is certainly not the first time that the international climate change regime has been in this position. The first time we were in this position is when George Bush rejected the Kyoto Protocol. The second time we were in this position is just after the Paris Agreement entered into force during Trump's first presidency, and we are back here again. And this is the third time we've been in this position. I think in terms of the international climate change regime, what's interesting to note is there has been an evolution in the international climate change regime, and the US sort of withdrawals have come at certain points in that evolution of the regime. So when the US sort of withdrew from, or sort of refused to ratify the Kyoto Protocol after having signed it. It took the Kyoto Protocol far longer to enter into force because of the sort of entry into force requirements that were in the Kyoto Protocol required a certain emissions threshold to be crossed, which was much harder with the US out of the regime. So it did have a drag on the process back then, but at the end of the day, multilateralism did trump sort of unilateralism in that case, and I do mean, I do mean that pun intendedly, so that's the first time around, and then with respect to the second time around, the U.S. Withdrew, which was in 2017. This was just after the Paris Agreement had entered into force, but the withdrawal provisions of the Paris Agreement made it clear that it would actually take 4 years for it to come into effect, because it was a 1-year notice period, and states could only sort of withdraw after 3 years of it having entered into force for them. So as a result, the US effectively withdrew just at the tail end of the Trump presidency, and Biden sort of reinstated the US into the Paris Agreement shortly thereafter. Again, it had some implications at the time, but not the sort of catastrophic implications that others had predicted, because the US was beneath the radar, but very much part of the sort of negotiations. And now, this time around, the international climate change regime and the Paris Agreement is at the stage of sort of implementation. We have moved past the stage of actually negotiating sort of treaty texts and even COP decisions. Increasingly, much of the COP decisions are linked to, rather than interpretation of the treaty text, into implementation mode. And as a result of that, I think, at least, and this is my optimistic take on it, is that it's going to have less of an impact than predicted. Because a lot of the seeds for the sort of governance frameworks have already been sort of seeded across the world in different national governments. There is a lot more ownership of the climate change agenda across different stakeholders, and different stakeholders are involved in it and are sort of contributing to it. So it's not just nation states anymore. So I think, given the stage at which this particular withdrawal has arrived, while it may create some drag in the international process, might create some drag in financing and sort of implementation, at the end of the day, I think we will tide this over as well as an international community. And I'm optimistic that there will be other leaders that will step into the gap created by the US on this. I see.
I could address the questions on Article 6 and carbon credits. So one of those is, what do you think are the risks and opportunities for net zero linked to recently operationalized Article 6 of the Paris Agreement? How are they relevant for domestic binding commitments to net zero? So I think this is a really complicated issue here, because one direction in which our analysis pulls is that states should be trying to act consistently with 1.5-degree aligned global pathways. And when you try and work through what that means for individual states, particularly for developed countries, if we're making an allocation of the remaining carbon budget, greenhouse gas budget, on the basis of common but differentiated responsibilities and fair shares, as Lavanya has argued in an earlier paper, then essentially they need to be extraordinarily rapidly reducing their emissions almost to net zero sort of now. And there is a tension there that arises between responsibility and feasibility. And one way of bridging that gap is to say that states should be supporting emissions reductions and removals in other countries, in addition to what they're doing domestically. And so there is a role there, I believe, for Article 6. But the key word there is in addition. And I think a lot of the way in which the international cooperation and carbon credits are being used at the moment, or are expected to be used within these long-term strategies, is not necessarily to add to the sort of highest possible ambition at the domestic level, but to displace ambition from one country to another, to buy the ability to keep on emitting at a higher rate than is in keeping with your responsibilities. And so I think one key first step there, as we discussed with some of these other guardrails on CDR, is transparency, right? So when you look at what states are saying about their reliance on Article 6 within their long-term strategies, they're very, very rarely putting any limit on how much they're going to rely on it. So we have a lot of states saying that they might rely on international carbon credits without putting any limits whatsoever on that. And with the consequence that it becomes very difficult to ensure that they have integrity in domestic emissions reductions. And it's sending mixed signals for the changes that need to happen. So it's a difficult balance, but it's a very important point. Thank you for raising it.
If I could sort of address the question on which courts would this most likely be litigated in. So on the CDR issue, I think the courts that, at least at first blush, the courts that will be most likely to be litigated in is national courts, where a particular country, for instance, has a sort of net zero target that is embedded in law, but doesn't have sort of action plans that clearly demonstrate how that state is going to get to that net zero, or if it does, and plans to sort of rely heavily on CDR, but doesn't provide enough information on sort of availability, feasibility of that CDR, sort of the economic, social, environmental impacts of sort of using that pathway. This could be challenged by actors depending upon the judicial and legal culture, of course, that allows standing and sort of is sort of open to public interest litigation. But this could be challenged in national courts, and in part for sort of violations of procedural obligations as well. So many jurisdictions have sort of procedural guarantees for in relation to environmental information, and this is something that potentially sort of individuals and sort of citizens action groups can sort of litigate to make sure that they get sufficient information on how their state is planning to meet their sort of net zero target and their sort of and their short-term sort of national determined contribution as well, aligned with the net zero target, how they can actually sort of do that, and how they plan to, what CDR forms of CDR they plan to rely on, and whether that is sort of in keeping with the standard of due diligence that a state is required to exhibit in relation to actions that it takes to address climate harms. So both in relation to substantive sort of criteria for due diligence, whether that state is actually exercising due diligence or not sufficiently due diligent, aligned with the high and stringent standard of due diligence that we've laid out here, but also procedurally, whether it's providing enough information to demonstrate compliance or lack thereof with that standard of due diligence. So it's most likely to be litigated in domestic courts initially, but potentially elsewhere as well. But the more general sort of identification of a due diligence obligation that we have done in this paper and in our talk is something that is also being litigated in international courts. So the extent of that obligation, the standard of due diligence, what criteria are being used to determine that due diligence are in submissions before the International Court of Justice, for instance, in the ICJ's advisory opinion on climate change. So we will wait to see to what extent the International Court of Justice sort of identifies and concretizes the standard of due diligence. But it is a very live issue, and aspects of these issues are going to be litigated in different courts. Thank you. Do you want to?
Yeah, maybe I'll address that first question. How optimistic are you that states will willingly sign up to or strictly observe an obligation to avoid or time limit an overshoot of 1.5 degrees, particularly given recent perceptions that powerful states are willing to cherry pick international law according to their own immediate selfish interests? I think this is an extraordinarily difficult one, right? So I think part of the message that we're bringing today is that states have already willingly signed up to a limit of 1.5 degrees. And within the context of the UNFCCC and the Paris Agreement, that limit carries with it an implicit limit on the extent of overshoot that states should be acting consistently with. So the question isn't so much what states have signed up to, it's will they follow through on their commitments? And I think one response to that is linked to the previous question about how this ends up finding its way into national courts, where what we have seen in some of these major climate cases, most recently perhaps in Klima Signorinien, the decision by the European Court of Human Rights, the analysis was there in a regional court based on the 1.5 degree with no or limited overshoot as sort of an underlying premise of the obligations that they thought the Swiss government had. And we've seen similar dynamics in courts at the national level in Urgenda and in the Netherlands and Neubauer in Germany. So the commitments that states sign up to at the international level, though, as you say, they may cherry pick which ones they want to abide by, they do have a way of finding their way down to the national level, both within the legal system and then within the political consequences of not carrying through what you've committed to. So it's difficult to say the level of compliance that we can expect to this, but certainly we can say that acting in line with our obligations means minimizing overshoot to whatever degree you possibly can.
So perhaps I could pick up on that also in relation to another question. Why would a temperature overshoot scenario be a viable solution given the potential risks? So I think that is what we're trying to argue, that actually most overshoot scenarios would not be in keeping with sort of requirements, the normative framework of the Paris Agreement and the standard of due diligence as well. Of course, Article 2.1 of the Paris Agreement doesn't sort of specifically address the issue of overshoot. It just identifies the temperature goal as well below 2 degrees and pursuing efforts towards 1.5 degrees centigrade, which suggests that at least that there is a range, that is a single goal with two sort of elements to it. It's well below 2 degrees and 1.5 degrees is well below 2 degrees as well, with the emphasis being sort of shifted over time to 1.5 degrees centigrade. It doesn't also identify a particular time point by which we need to reach 1.5 degrees. So there is some interpretational ambiguity in Article 2.1 of the Paris Agreement. But having said that, subsequent COP decisions and sort of the best available science indicates that 1.5 degrees and a sort of minimum overshoot, to the extent possible, needs to be sort of factored in. And so we would say that most scenarios that have significant overshoot and then return to 1.5 are not in keeping with sort of Paris, but also the standard of due diligence expected of states. Admittedly, there are sort of temporal dimensions here. This is something that we address in the larger paper that this talk is based on, in that it depends on when we make this assessment. As we were discussing earlier, if this assessment had been made a few years ago, we would have said no overshoot would be countenanced under sort of Paris aligned and sort of due diligent framework, states due diligence sort of compliant framework. But today, given where we are at in terms of sort of emissions and the fact that we've crossed 1.3 degrees at this point, and 2024 was the hottest year on record, and sort of year on year, we're sort of exceeding all expectations in terms of temperature rise. The possibility of exceeding 1.5 is quite high. But at this point, what we think is Paris aligned is sort of minimizing that overshoot to the maximum possible. So we minimize the overshoot, minimize the sort of extent of overshoot, the magnitude of overshoot, and the length, the duration of overshoot, to avoid the tipping points, to avoid the catastrophic, irreversible impacts. So yes, given the risks and uncertainties, CDR does play a role in this. And we think, again, sort of the reliance on CDR would be excessive reliance on CDR is problematic from from the perspective of the standard of due diligence, as well as sort of the Paris Agreement's core normative sort of expectations as well, and sort of temperature and net zero goals. Any other questions that we wanted to pick up?
Perhaps the one on how relevant is it to base climate scenarios on massive amounts of CDR when we still have no proof that large-scale carbon removal will be feasible? Isn't this, in a way, giving policymakers an excuse to delay action on emissions reductions? So I think as we've discussed through this, there are real risks of this sort of mitigation deterrence effect, sometimes called, where the supposed possibility of large-scale CDR is used by policymakers as a justification for delaying action on emissions reductions. It's one of the main risks that we've identified. And I think there is a real problem here in terms of how much CDR is involved in some of the scenarios that we base our best available science on. And largely the reason for that has been that we're generating models that are trying to reach the answer of staying below 1.5 degrees or below 2 degrees. And because of our previous inaction on emissions reductions, we've ended up at a point where essentially the only way to do that is, at least to some extent, to pursue carbon dioxide removals. So within that context, the question really needs to be, how do we ensure that the role that those removals are playing is a feasible one? And partly that's starting to take into account potential limits on how much of this we can do. So for example, there's been a lot of attention recently on trade-offs between bioenergy, carbon capture and storage, and the land sink, and also the tensions between the land you need for either of these and other priorities we have around agriculture, for example. So there are limits in that respect that we should, as far as possible, be trying to incorporate into states' strategies. They should be taking these considerations into account. But the flip side of this is that the thing that demands all of these removals is the fact that there are still ongoing emissions in these scenarios. And I think we should be thinking very seriously about what is making up those emissions and think seriously about whether they're really inevitable, whether they're something that we can really do without. And I think these are the questions that states need to answer to respond to these feasibility problems.
So maybe I can pick up another question on climate litigation. Have national courts relied on the Paris Agreement in finding budgets or targets inadequate? Relied on is sort of term that encompasses a lot of different ways in which national courts sort of relate to international law. I would say national courts relate to international law, like the Paris Agreement, in different ways. Very few of them will be directly applicable, and very few of them will directly apply the Paris Agreement. This is only in sort of, obviously in states which sort of consider international law directly applicable, the monostates, as it were, in domestic law. So for the vast majority of states, the Paris Agreement would have been, in some respects, integrated into domestic law in some way. And if that's not the case, then the Paris Agreement would at least be used in national court decisions to bolster or strengthen arguments that have been made, to provide sort of a context to help with interpretation of national legislations or national constitutional texts. And that's the context in which the Paris Agreement has mostly been used in national court decisions. I think in particular, Article 2.1 has found, and the sort of temperature goals have had a lot of normative salience in many decisions, including Klimaat-Zak in Belgium, but other court decisions as well. The Rocky Hill mining decision in Australia. These are cases that have relied on, in the sense of sort of use the Paris Agreement as a sort of providing a normative direction and pull, and have used the sort of 1.5 degree and sort of the temperature goals as providing a normative direction of travel for judgments that they make. And some of these judgments have actually found sort of national targets inadequate. So there are these framework cases in which national targets have been found inadequate. And most of these cases do refer to the Paris Agreement and its Article 2.1 sort of temperature goal in particular. This sort of includes from, I guess, Urgenda to Klimatzak. There are many cases that actually do that. But do they directly rely on the Paris Agreement to find a carbon budget? Probably not, but it's certainly part of the context for the decision making and provides normative direction and pull to the judgment that they have. And this is actually also true for sort of the Klima-Seniorin case as well. So the European Court of Human Rights. Are there any other questions that we have time to answer? Okay, we have few minutes. Anything you were to?
There was a question I saw about whether there's a central database which evaluates NDCs in terms of credibility. So that's a very good question. There is the Climate Action Tracker, which does a very good job of interrogating NDCs, and for example, picks up on states using dodgy accounting in how they're adding up the different aspects of their mitigation strategies. And also, sort of in addition to that, one of the things we did as the first of the two papers that we mentioned was go through not only all the NDCs, but also the long-term strategies that have been submitted to the UNFCCC, and looked for the information they were providing and flagged up feasibility and credibility concerns. So that the data set for that will be available when that paper is published. But the summary of those conclusions you'll be able to find in the preprint version that's available online that I think has been shared. Yes, we have been tracking this kind of information. The Climate Action Tracker, as the next set of NDCs come out, would be where I would go as a first port of call.
And the UNDP has also been helping many developing countries with sort of strengthening their nationally determined contributions, sort of looking at elements of their nationally determined contributions that can, elements that can be enhanced in relation to both credibility and accountability, and sort of making sure that sort of all the I's are dotted and T's are crossed. So that's another sort of source, I think, for looking at sort of credibility of NDCs and how those the credibility of NDCs can be enhanced. I think we're pretty much at time at this point. So to see, so thank you very much for sort of a fabulous set of questions that kept us on our toes, and which will really help us also sort of think through the final versions of the papers that we're doing, which we hope to share with you in due course. We would also like to sort of end by plugging the next seminar in the series, which is a week today at the same time. It's on zero carbon energy systems, the heavy lifting for net zero, which is by Professor Nick Eyre from the Zero Institute, and we'll post a link to it in the chat. So please tune in next week, same time, same place, and it's netzeroclimate.org is where you need to register for Nick Eyre's seminar. So thank you very much for being a fabulous audience and great questions, and good luck and have a good week.
Thank you.
Thank you.